In a legal case, we have to prove that the manufacturers of asbestos products knew or should have known that asbestos was a danger. Hi, I'm Joe Williams. I'm a mesothelioma trial attorney in New York City. And I want to talk to you a little bit about some of the legal standards as they apply to a mesothelioma legal case. In a case on behalf of a victim of mesothelioma against the manufacturers of asbestos products or companies that use asbestos with reference to their product, we have to prove that those companies either actually knew that asbestos was a hazard and didn't warn anyone about the danger, or that they should have known with a little bit of reasonable research that asbestos was a hazard and they should have warned end users and workers about the dangers of asbestos. In order to prove that they actually knew, one of the ways we do that is through the company's own documents. And these could be documents related to research and development that the company themselves did in which they learned asbestos was a hazard. Or it could be internal memorandum or letters where employees or officers of the corporation are talking about the asbestos hazard. We could also show their knowledge, their actual knowledge, through their membership in industry trade organizations. Organizations where they have meetings and talked about the asbestos hazard, or sent out publications to that particular company in which articles or information was present in the publication about the hazards of asbestos. We also can introduce citations or fines in some cases levied by OSHA or other municipal entities against a company's manufacturing plant, wherein there is a fine or a citation related to asbestos dust at the plant. And in those cases where we're proving that a company should have known, we do that with the general information that was out there for the world to evaluate and see, especially that was available to manufacturers of products that had asbestos in them. And this comes in the form of medical journals, in publications such as the Journal of the American Medical Association, known as JAMA, or its counterpart in Great Britain, known as The Lancet. And the importance of those medical journals is that every doctor who's a member of these medical societies gets the journals, and in the past century, those journals were filled with articles about the causation between asbestos and mesothelioma and asbestos and cancer. And importantly, many of these corporations had doctors on staff who were in possession of these articles. Additionally, there was information in the mainstream media. In the 1950s, Newsweek magazine had articles about asbestos. In 1953, the Encyclopedia Britannica listed asbestos as a cause of cancer. So the should have known standard takes into account what companies should have known with a reasonable amount of research into this issue of asbestos dangers before selling the product containing asbestos into the stream of commerce for end users and workers to use every day at work. I'm sure you have many more questions about the legal standards that apply to a mesothelioma case, and we can answer your questions. I encourage you to call the number below. That's my office number. I'm Joe Williams, and we can answer your questions. Thank you.